In this section, we will look at topics that are essential to an understanding of powers of attorney to support your ability to provide care for any resident who may have or be in need of one. And our first topic poses two basic related questions. What is the purpose of a power of attorney? And is a resident required to give up independent decision-making authority in order to have one? In answer to the first question, a power of attorney is intended to be a convenient way for a resident to give a chosen, trusted person the authority to make decisions that a resident has independent authority to make while a resident still has decision-making capacity, and to plan for a time when a resident may not have that capacity. In terms of convenience, we should note that a power of attorney must be a written document, but no particular form is required, and that they are regulated by law. Fortunately, it is not necessary for you to have a complete understanding of that law in order to be able to routinely work with either a resident who has a power of attorney and/or the resident's representative. It will be necessary, however, to point out changes in the law that became effective on January 1, 2017, although I will not discuss every change that was made. If you have an interest in reviewing them and the law governing power of attorneys, you will find more information in the reference guide. Now, in answer to the second question, is a resident required to give up independent decision-making authority? A resident does not and is not required to surrender independent decision-making authority in order to have a power of attorney. A resident retains independent decision-making authority over all personal and property-related affairs, even if the resident hasn't authorized a representative to act through a power of attorney, provided the resident has capacity. You may have noted several times that I refer to a resident's capacity. So let's take this opportunity to consider the concept of resident's capacity and how that relates to a power of attorney. Well, what is capacity? On the most basic level, when we talk about a person's capacity, we are referring to that person's ability to think clearly, recall facts and events accurately, to communicate thoughts, plan and execute actions, and then to understand the potential outcomes of those actions. Additionally, a person's capacity is ordinarily assessed on a decision-specific basis rather than on a global one. The law takes into consideration various types of capacity, such as the ability to execute a will, that's testamentary capacity, contractual capacity to enter into a contract or conduct a transaction, or to provide consent for health care, that's informed consent. The law also takes into consideration the concept of legal capacity. And it's important to understand that that concept is a purely legal one, and that a medical opinion is relevant, but may not be the deciding factor that leads to a determination that a resident either has or lacks legal capacity to make decisions affecting the resident's personal and/or property interests. All persons over 18 are presumed to have capacity to make choices and decisions concerning all aspects of their life, including health care, activities, and personal associations. This presumption applies equally to persons who are residents in a long-term care facility. Importantly, the state residents' rights law also protects a resident's right to make choices and decisions concerning all aspects of their residence in a long-term care facility, and to exercise reasonable control over life decisions, including those that affect health care, activities, privacy, personal associations, and communications. Even where it has been determined that a resident lacks capacity to make certain decisions, or that capacity is subject to question, a resident's expressed choices and desires, written, verbal, current, and historical, must be considered and respected consistent with and in support of the resident's guaranteed resident rights. Capacity is critical for a power of attorney because a resident must have had capacity in order to validly execute, that is, sign, or terminate, that is, end a power of attorney. Additionally, a validly executed power of attorney and the representative authority it provides will become invalid at the point the resident is determined to lack capacity, unless that resident has planned ahead and ensured that the power of attorney contains language that enables it to survive that determination. And this is what is referred to as a durable power of attorney. More on that in section 2 of the presentation. You may well ask, is there a definition of capacity? Well, the law contains a number of definitions that are used to describe capacity for specific purposes, including the provision of informed consent for health care and assessing the need for the appointment of a guardian. As of January 1, 2017, and thereafter, the law governing powers of attorney defined incapacity in part as an inability to manage property, business, personal, or healthcare affairs because of an impairment in the ability to receive and evaluate information or make or communicate decisions, even with the use of technological assistance. Now, some points to consider when applying this or any other definition concerning capacity to a particular resident or situation. First, it should only be done with a consideration of the existing factors that might influence or affect the person's capacity. We'll take a look at those factors presently. And second, this is a new definition, and how it will be interpreted and applied is yet to be formally determined. Long-term care facility administrators may choose to exercise their discretion to seek legal advice concerning the meaning and application of any particular definition or the concept of capacity in general to any particular resident or situation. And so how is capacity determined? Well, there is no single test to determine capacity. Concerned professionals ordinarily conduct and rely on a number of different assessments and examinations in order to reach an opinion regarding a person's capacity. A power of attorney may contain instructions about how the lack of capacity can be determined. For example, it may state that one or more physicians who know the resident may make that determination. In the situation where a resident has a court-appointed guardian, a court has formally determined that the resident lacks legal capacity to make some or all decisions regarding personal or property interests. However, except where the court has appointed a guardian, it's far more likely that a resident's capacity has not been formally determined. And that person's capacity can vary over time, subject matter, and be influenced by various factors. A person's capacity can be influenced and affected by a number of factors, including life experience and education, medications, chemical dependence, time of day, events that produce anxiety, depression, or grief, mental illness, vision loss, hearing loss, strokes, dementia. The existence of any of these factors must be taken into consideration when attempting to assess capacity, as they can individually or in combination provide an incomplete and inaccurate picture of any person's cognitive abilities. So how should a resident's decision-making capacity be determined? Well, in the absence of a formal determination, and where a resident's decision-making ability is subject to question, that ability should be considered at the time the resident is required to make a particular decision or take a particular action, and it should take into consideration any factors that can influence or determine or affect the resident's capacity at that time. This flexible approach will both appropriately take into account and the fact that the resident's ability to understand and make decisions can vary over time and according to subject matter, and ensure that the resident's desires and preferences are considered and respected, consistent with the rights guaranteed the resident by law. Once again, long-term care facility administrators may choose to exercise their discretion to seek legal advice concerning the meaning and application of the concept of capacity in general and to any given situation.